Awesome. We are there. So let's talk about some money moves for the savvy businesswoman. Of course, I have to give you my disclosures. This is not a representation of my broker-dealer, which is Securities America. These are simply the thoughts of my own and my own experiences. This is not intended to be a financial advice or tax advice. Again, it's literally for educational purposes only. So let's set the tone or set the stage a bit with challenges with women in investing. Some of you may or may not have seen this particular slide before by Fidelity, but essentially what it is saying is that many of us are eager as women to learn about financial planning, but we don't want to talk about it. And only about half of us are considering talking about it with a financial professional. But then the flip side of that, we're all actively or proactively saving. So we are doing a lot around saving, not necessarily a lot around investing. And when we are, we're doing it DIY. So we're kind of doing this thing in silence. And if you're a woman of color, maybe all women, but specifically women of color, this is probably the way mom operated, grandma operated. So we see it as normal, but we don't know how many opportunities they missed as a result of not having those conversations. So if you don't get anything else out of today's talk, I really want us to begin to be much more open about having those conversations. Now, you're probably not surprised about seeing this data about women saving. You probably hear it all the time that, women are very conservative, men take risks, but I will submit to you that women see money as safety, men see it as freedom. And once a woman feels safe about her financial future, guess what? She takes just as much risk as women. And I know that I'm talking or preaching to the choir because guess what? We're all women in business. That's a risk. We're already risky, right? So don't believe the hype about we're just conservative. It's just, again, we want that safety there first, and then we're ready to take on anything else. Now, let's talk about how to get started for investing for a lifetime. Again, we were taught years ago, just put away 10% or save for the rainy day. But the reality is we have different phases in our life, and different things happen at different phases. So we really have to prepare for phases of our life. And our wants and desires change as well. And sometimes money change. I tell my sons all the time, you all were born in different money. Don't compare what I did for one with the other. So let's talk about this money momentum in every generation. So early on in our careers, we learn a lot about holistic budgeting and our approach to budgeting. Hopefully, many of us have passed that. But if we had to have a reset, maybe we are back at square one. Again, life happens to us. We definitely want to save and invest early for retirement and our other financial goals. The earlier we save and invest, the less we have to put away. And then we also want to apply the 50-30-20 rule. So 50% of our income to take care of our needs, 30 to take care of our wants, and 20 to take care of our future. But in some cases, we may want to flip that a little bit, and there's 50 to take care of the needs, 20 to take care of the wants, and 30 for the future. It really depends on what our own individual goals are. But at the end of the day, the thing that we want to do is make sure that every dollar has a job. There's no free check. We have to throw that whole thought process out of the way. There is no free check. Every dollar needs to work. And then if we start with this 50-30-20 out the gate, or if we had have started with it out the gate in our early careers, we would have avoided lifestyle creep. What happens is once we get into the money and our lifestyle start creeping, and then when we feel it's out of control, now we want to pull back. Well, guess what? The liabilities are already out there. But if we could start coming out the gate with that 50-30-20 and never going over that 50%, we'll never feel bent over a barrel, because 50% of our income is taking care of our needs. Everything else is icing on the cake, and we're creating the life that we worked so hard for to live. negotiating our salaries. That's something we're just now learning to do. We didn't do that in the past. We just look at what people offer. We didn't counter those things. We didn't, if we were already inside of organizations, we did not talk about salaries because it was deemed illegal for us to talk about salaries. So we didn't know we were sitting beside peers who were making more money than us. But now, if we actually know our value and we can articulate that to a company as an early career person. So when I say that, I'm not saying how many tasks I do. That's not necessarily equating to what the bottom line looks like. You need to be able to show them how I'm making the company more money or how I'm saving. You need to be able to quantify that. Then ask for your value. Let them know what you bring to their bottom line. All right. Same thing with our prices and goods and services, because I know a lot of us are sometimes dualpreneurs, right? So we work with a W-2, we have a W-2 firm, and then we have our own companies. But we need to be able to price our goods and services appropriately, not discounting ourselves. Know our value, do your homework, know your numbers. And I'm not going to try to harp on that one too long, but that's one of the ones I get really passionate about because I feel like somebody had told me this, my life will look totally different right now. Now, let's talk about those of us who may be mid-career. Definitely saving in the workplace retirement plan, if that is available to you. Upskill to increase our value in the marketplace. So this means just because I have a CRPC or MBA or I'm an attorney or what have you, I still need to increase my value to the marketplace, continue to upskill. Like I need to make sure that I am constantly being a master of my craft, a student of life. I can articulate my value, that I'm timely and relevant in the current marketplace, that I'm always focused forward. I'm with cutting edge technology, all the things to propel my clients forward. That's what they look for in me. And so if I'm not bringing them new, rigorous content and opportunities, then guess what? I'm not really upskilling and bringing value to the marketplace. I've become a commodity like everybody else that's in it. And if you're not a W-2 employee, guess what? As a business owner, you can still have a retirement plan. Many of us don't know that because wealth management does not come to us because they feel that we don't have the investable assets. But if you have the income, you can still set up your own retirement account, whether it's a SEP RA, a solo K. Oh, by the way, the solo K works just like a 401k. If you're an individual business owner and you want to put your husband in the solo K, now he has a 401k opportunity too, and he doesn't have to work for your company. So these are tools that are not readily available to us. Then you can set up a 401k too if you have employees, but the big dog on the block is that cash bonus plan. If you could show me income for 3 years that has been consistent, oh, I can really show you an advanced tax saving strategy. For instance, I have a client that basically put $297,000 a year off in a cash bonus plan. Guess what that reduced her taxes to? It saves her $97,000 in taxes. So she's put this money away from her for her future. And she also has this huge tax break where else she would have been paying $100,000 to Uncle Sam. And so again, these are opportunities that are available to us, but you have to have the right individual who knows your business, understand your income cycles, and know that you can sustain this. Because that's the thing, you can't do it for 1 year and the next year decide, oh, well, no, I don't want to do this, because you're going to have to, that $297 commitment that she made to that cash bonus plan, she has to do it for at least 3 years for this to work. Because Uncle Sam is smart enough to know, oh, well, we'll just keep trying to change things up just to avoid taxes. But it's available. Can you imagine that? So if you're behind on retirement, here's a game changer. Here's a game changer. Level up our services and goods in the marketplace. So we're always talking about how we need to increase our prices, but don't increase your prices if you haven't leveled up your services and goods in the marketplace. Come on, y'all, we got to show up. You know, we've always had to show up twice, twice as hard as someone else in the marketplace. But come on, y'all. Let's show up in excellence. We all have, and again, I don't see the demographics of everybody because I can't see everybody. We all have that Black girl magic or that woman magic if you're not a person of color. Let's level up our goods and services. Let's be the best at what we do, right? Understand our financial position if we're in a two-income household. It goes back to that 50-30-20 um, 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 formula I gave you a moment ago. If you're in a two-income household, and if you can use that formula off of one income, can you imagine what the two of you can do together? This is a conversation that I have been trying to have my male financial planning brothers to have with the men. It has to come to a point that we have to stop living separate lives because we're leaving too much opportunity on the table when we live these financially separate lives. It looks cute on Instagram. It looks great on Facebook, the vacations and all of that. But the reality is when you pull back the curtain, only one of the couple is sitting in one person's shop and then the other one is sitting in someone else's shop. We got to do this together. This is how we build generational wealth and not leave anything on the table. We need to understand our investment portfolio. What's in it? Does it fit our risk profile? Does it fit our time horizon? Does it align with the goals that we're trying to achieve? Those are things we need to understand. Establish a plan for non-retirement and retirement assets. I think the thing that we hear the most when people do approach us about financial planning, we're always talking about retirement, but you got to live between now and retirement. So we really need to remember, I was talking about all the phases of our life. We need to be able to fund all the phases of our life. And I'm going to look for Ariel's question in the go back to solo K and RA. I certainly can. That's an easy button. So the SEP RA is basically where you could put up to 20% of the income that you earned, right, into a retirement account. And you receive a tax break for that because it's tax deferred. So now that can go all the way up to, I think this year it might have bumped up to 62,000. So you have an entire bucket to fill versus if you had a traditional RA, you could only put up to 7,000. So there's magic in the SEP RA alone. Now, when you get to solo K, and usually with solo K, I recommend that my businesses get to at least $80,000 consistently in income because with the solo K, it operates like the 401k, which means these payments have to be made monthly out of your payroll. So if you're not already consistent with your payroll and your cash flow, then the SEP RA, I just told you can put up to 62,000. So that 61,000. So that gives you, a pretty good runway of what you can put away. But now when you get over to the solo K, now this is where a lot of magic happens. Now you have the same equivalent of the 401k, where now you can put away up to the 401k limit for the year. So that could be 20,000, just depending on your age. And then you also have what's called a profit sharing sleeve. I'm using both arms here. So this is the 401k sleeve, and then you have a profit sharing sleeve. The profit sharing sleeve is 25% of your earned income. So you got this limit for the 401k, and then you have the profit sharing sleeve. Now, the profit sharing sleeve does not have to be filled out of payroll throughout the year. It can actually be filled later in the year when you're ready to do your taxes and you see that you've had this profit and you want to make sure that you're taking advantage of any tax savings, additional tax savings. Now you can add up to 25% of that earned income on top of that 401k. Now, when I said this is a magic, the magic is if you have a life insurance need that exists and you don't have life insurance, that profit sharing sleeve I was speaking of, you could put a whole life policy into that profit sharing sleeve. So now your insurance premium is now tax deferred. So there's a lot of things that are, again, available to us that we don't necessarily know about because wealth management is not talking to us because they don't see readily made investable assets. But as Black business owners, the same tools that other corporations have, we have access to these opportunities too. And so this is how we learn to get ahead of the game and really make our business work for us. You don't want to be in business just to create a job. If that's the case, I could just sell you some shares of Coke. And when when it's over, it's over. The reality is you don't set these things into play. You're not paying into Social Security. Not that Social Security can fund us in retirement, because it only funds about 36% of our retirement. But the reality is, I've seen business owners with a $200 monthly Social Security check. Now, how is that going to help? So you wonder why some people in some professions have to work literally till they die, or can't physically work anymore, because they haven't funded Social Security. So see, while we feel like we're winning and hustling and bustling on the front end, the back end could be really tough if we don't strategize every phase of our life. All right, I know I'm pushing up on time now. Let me roll through, but any more questions, just send them on through. Now, retirement, we just want to make sure that we, tax efficiently distribute everything. And I'll talk about a bit of that in a moment. We want to make sure that we have long-term care. My mom's 93 years old. I just moved her in my house in July. So I'm probably going to live pretty long. And then her first cousin, just had her 102nd birthday. So the reality is we're living longer. Technology, medicine, all these things are helping us to live longer. And then we want to, leave something, generational wealth, to our family members. And I won't steal any of Stephanie's thunder. She's going to get over to that in a moment. But that next phase is our income distribution, because everything I talked about was the accumulation side, building up to that wealth. But now we got to figure out, now, how are we going to eke this out without necessarily paying Uncle Sam all of it. And what I would share with you, there's basically 3 buckets for taxes. It's the tax me now, so that's your earned income, or if you have capital gains taxes because you have investments. So when we think about Warren Buffett and the fact that his admin paid more in taxes than he did, it's because all his is passive income. So he's taxed at a lower rate. Ultimately, hey, I think we all would love to be in that space, right? That I could pay for my living off of passive income. It don't have to be earned income. That's a beautiful space to be in. And then, dividend tax rates too. Then there's the tax deferred bucket. So this is everything that went over into the 401k that I was sharing with you a moment about. Anything that's tax deferred. Then you have this tax-free bucket. This is anything that you bought with after-tax dollars that will never be taxed again in the future and can be withdrawn on a tax-free basis. So here's the deal. I'm gonna make this one quick. This one right here, this tax deferred, this is the bucket that Uncle Sam controls the most. These other 2, you can kind of control, depending on what choices you make and what strategies you put in place. But that tax deferred, when you turn 72 and a half, which, yeah, he just bumped it up 72 and a half, you're going to have to withdraw 3.6% out of that bucket, whether you need it or not in retirement. And that's going to automatically push your tax bracket up, unless you have very little money in these other 2 buckets, right? You're going to pay. He's going to dictate when you take money out of that bucket. So we have to be mindful. We need all of these buckets working, and these 2 can help you decide how to deal with this second bucket, because he's going to determine this one. And that one there is what's going to determine how your Medicare premium looks like in the future. It's also going to determine what your Social Security taxation is. So anything over $36,000 that you get in Social Security and Social Security and retirement money, pension, any of those things, then guess what? Your Social Security can be taxed up to 85%. So the distribution game is very real. Here's another thing: sequence of return and retirement. This is why you need that financial professional. Using a calculator to tell me that I need 10 times my salary when I retire is not a good litmus test. It's very misleading. People, I'm saved, I'm set, and they don't even want to have a conversation. They don't know about distribution. So here, these people, they both retired with the same amount of money at the same age, $100,000. The difference is one retired in an up market, one retired in the down market. Remember I talked about that 3.6% Uncle Sam's going to make you take out, regardless of whether you need it, regardless of what the market does. Well, the investor in blue retired in an up market. So in year 15, he has $105,000, $944 left over. Look at the green investor. Green investor is down to $35,889. Now, mind you, this is somebody that retired at retirement age. So now let's just kind of hypothetically do the math. This person is conceivably 80 years old. I just told you my mom, 93 years old. I just told you we all have a high propensity of living long. 35,000 will not carry her the rest of her life. So that's why we do retirement income distribution. We actually create vehicles for all these phases of retirement. So you have to have a financial professional to help you to build this. It's so nuanced. Financial services is so complicated. This is why we have these conversations, to make sure that people do not outlive their money and they're able to leave a legacy. So you see all these different things, all this works in tandem, so that every phase of your life, we call this the go-go years, the first few years of retirement, because you're going to go somewhere. You're going to go. Then you go slow down because the grandchildren or great-grandchildren come on the scene, and then you're going to kind of be still, right? So you want your money working in the right phases for you based on the activity level in your retirement. Suddenly single, I'm going to run through these and I'm going to stop because I know Stephanie need to talk. Here's the deal. We're going to all be single at some point, whether by choice, divorce, or widow. The average age of a widow is 57 years old. You know what a widow's tax penalty is? This year, if my husband dies, I'm going to pay a widow's tax penalty. Why? Because last year, there was 2 people in the household, right? So you get that tax break for the 2 people that are in the household. Now we're down to 1, right? So mathematically, now I'm only getting credit for 1 individual, but everything else is the same. So now I'm getting tax heavier. Decrease in Social Security benefit. We're going to go to 1 Social Security benefit, whoever is the highest. There will no longer be 2 Social Security benefits. I need to have an income replacement strategy in the event that I pass or he passes, because our lives will change. I need to take in consideration healthcare costs, long-term care, making sure financial planning documents are in place. If I'm in a blended family, and I'm not going to take Stephanie's thunder, I need to make sure everything is earmarked the way I want them to go. Because guess what? Georgia has something for you. Georgia basically says that 2/3 need to go to your children and 1/3 goes to the spouse. So if you haven't made a different type strategy, because suppose really there's only 1 child and then the spouse, what does that look like? And is that child your biological child? I have seen some pretty sad funeral days where there was a lot of discontentment with the blended family at the funeral. I'll let Stephanie tell some of those stories. The great divorce. Do you know how many people are getting divorced after 50? Do you know what that looks like? Well, for a man, it changes his life. About 27% of his life will change. For a woman, 43%. And we're the ones that's going to live longer. Starting over like that is horrible. The Social Security and Medicare cliff. So if you're nowhere near Social Security age, who's going to pay for your health care? Do you have the money to pay for that? A decrease in Social Security benefits. Again, we need income replacement strategy. There's going to be healthcare costs that we have to think about between now and Social Security. We need to make sure we have estate planning documents in place. There's just so many things that we have to think about every phase of our life. And there is just no way possible that we can DIY this thing. And with that, I'm going to turn it over to Stephanie and I'll check the chat for questions. Thank you. Oh, you wanted me to talk through a graph. Sorry, I missed it. Which graph was it?
No, you're fine.
Okay, thank you.
Well, that was terrific, Sybil. I think you helped me with a lot of things that I've been dealing with and I've postponed. So to follow along with what Sybil just discussed, because I went through a divorce, et cetera, fast forward. So I will be calling Sybil next week because I have a huge tax problem. So don't wait till it's too late because I thought I had another year to get ready. Don't hesitate, have the conversation now. So to follow along with what she said, you don't want to go through all of the trouble that Sybil just discussed, only to pass away and have it go completely left because you didn't put a plan in place. So I'm going to try to share my screen. My presentation is not as pretty because I'm not creative, but it's just to show the points and the bullets for you. Okay. So I have learned in my own experience with women in probate and not planning, especially married women, they take for granted that because they are married, they are going to automatically receive everything. And women, men also make the same mistake of taking that for granted. That's just my bio, which Ariel already talked about. But I want people to pay attention to what I call the ABCs and Ds, which is essentially your assets, your beneficiaries, your children, and your deeds. At our age, 9 times out of 10, your husband is on his third marriage. It's a fact. And when he's on that third marriage, what I have learned in my probate and planning experience is that the wives, especially because we tend to live 7 to 10 years longer than our partners, they're not having these finance questions about what's happening with the estate, especially when there are children. And I have had nightmare cases where wives who have been the second or third wife for 20 to 30 years, they end up with nothing because either one, there was nothing in place, or two, which kind of goes hand in hand, is that he has children. Now the women, of course, we have children too. I have a daughter, but 9 times out of 10, when you end up in probate court, excuse me, it's the men's children that are suing everybody else. The women's children don't fight as much because we tend to plan a lot more than men do. That's just a fact. Men don't want to admit that they don't plan as well, and they don't want to admit that they didn't put anything in place for you. So you need to start asking them questions. I wouldn't go directly into the finances. I will come back as to how you should have that conversation, but I want you to have a full handle on the difference between your assets, your beneficiaries, your children, and deeds as a married woman or as a single woman, especially if you have children under 18 years old, and especially if you are a partner in a blended family. So your assets are essentially everything that you own, regardless of what that is. This bottle of water that I'm sitting here sipping on is my asset. This little timer that I'm going to start now so I don't go over my time because I'm a talker is an asset. However, anything that you own in which you have a joint owner added on or you have a beneficiary listed, those assets will automatically go to the joint owner or to your beneficiary, not including the house. And I'll come back to that. So again, your assets that have a joint owner or name a beneficiary will automatically either go to that joint owner or to the beneficiary. So what's the difference between your beneficiaries and your children? Your beneficiaries are essentially any person that you name to inherit anything from you. They do not have to be a relative. They do not have to be a lineal descendant. It could be Sibyl, it could be me, it could be Ariel, it could be anyone that you name, it could be your dog. Okay, so your beneficiaries is the person that you actively choose. You name this person in your estate planning documents to be your beneficiaries. If you live with a same-sex partner and you don't name them on anything, don't think just because this person is the love of your life and you've been with them for 20, 30 years that they're going to receive anything when you pass away if you did not name them as a beneficiary on anything. So just keep that in mind because that's another dynamic that's growing in our economy. And a lot of people are leaving their loved ones out because they're just taking for granted that just because they live together, they're going to receive everything. And I promise you, your family members will step in as soon as you're gone and kick that person out of the house. So your children, of course, are your natural lineal descendants. However, if you are married, it's your children and your spouse. So keep that in mind, your children and your spouse, not his children, your children. So the same thing passes, as Sibyl mentioned earlier, same thing applies when it's your husband. If he passes away first and his survivors are his spouse and his children, you are going to have to contend with his children. And 9 times out of 10, that's not a good place to be, because everybody is happy-go-lucky as long as everybody is alive, and what I like to call, the referees or the parents who want to pretend that all their kids get along, but the reason they get along is because mom and dad are there refereeing. And when they're gone, you'd be shocked to see what happens in court. So that's the substantial difference between your beneficiaries and your children. And keep in mind that if your children are under 18 years old and you don't have a plan in place, not only will your estate have to go through a probate to determine who's going to manage your assets, but if your children are under 18 years old and you didn't make a plan, your children might be left out there as orphans. Yes, it has happened. I had a case that involved a 2-year-old. We talk about it all the time. Client gave us permission. He lost his mother and his father at the same time. They had no plan in place. And it went from a guardianship petition to a full custody battle between the two families because there was no plan in place at all for that child. So again, if you have children under 18 years old and you don't have a plan in place when you pass away, they have to go to probate court to determine who's going to manage your affairs, your assets, but then who's going to take care of your child. So if you didn't name a guardian for your child and you're not with the parent, or the other parent was not did not legitimate, or you were not married to that child, you're setting your child up to go through foster care. And that's serious. It happens all the time. If you haven't read about it, it happens all the time. Please put a plan in place for your children, especially if they're under 18 years old. And don't take it for granted that you don't own anything, because we all have something. So you have to apply for a conservatorship, or the person who you leave in charge of your child would have to apply for conservatorship. And even if you are married and your spouse passes away and you have a child under 18, the court is going to require you to apply for a conservatorship. Why? Because just because you gave birth to that child does not give you any right to control any inheritance that that child has. Anything that child has is held in a protective trust, so to speak, until they're 18, because it is the parent's legal duty to provide for that child. Now, if that child has special needs and requires special care and a special van, then yes, you can get permission from the court to buy that special van or have accommodations made to your home. But keep in mind what I said, you need permission from the court. Now, if you have a plan in place, you put a trust plan in place, you don't have to go to court to get that permission. But if you don't, you have to go to court to get permission for your own child. So just keep that in mind. Now, deeds is another area that comes into play with married couples or people who are separated. I find that at least 70% of the time, married couples who own properties together, regardless of whether you purchased it together or whether he added you on or you added him on, if the deed is not properly titled, you're going to have to go through probate court. Everybody assumes that because his name or her name, or two hises or two hers, it doesn't matter. People assume that when there is more than one person named on the deed and one of those persons pass away, that the survivors equally inherit. That's not necessarily the case. There's this titleship called joint tenants, tenancy in common, and joint tenants with rights of survivorship. I'm not going to confuse you by going into that, because even my clients I'm working with are still confused by it. But the point is, you want to be very well aware of how your deed is titled when you start making your plans, because the worst thing you can do, one of the worst things you can do, is have a plan in place, not have someone look at your deed to examine how the ownership is held, and then properly prepare for that in your plan. And that's one of the main things that distinguishes my office from the average estate planning a probate attorney is we automatically pull your deeds regardless of whether or not we're doing probate for you or planning, because it's a huge issue. When I was married, we bought our first home together. And what happens is your closing attorney doesn't represent the buyer or the seller. The closing attorney represents the person who's putting the money up for you to buy that house. They represent the mortgage lender. So when they're preparing their deed, it's pretty much an automatic form. They don't care if you're married or not. So they put a title on my deed that I was aware as an attorney was inappropriate for my relationship. So I made them change it immediately. But you're not going to catch that. So when you have planning in place, make sure the person you're working with takes a look at your deed as well. So those are the most important topics that I think it's easy for family members to focus on, is the distinction between your assets, your beneficiaries, your children, and your deeds. So with the assets, I'm going to go back into your probate versus your non-probate assets. So the assets I mentioned earlier, where you name a co-owner or a beneficiary, those are non-probate assets. What that means is, as I stated earlier, those assets will automatically transfer to the co-owner or the beneficiary unless it's a home that's not properly titled. But if you have assets, such as you probably have a bank account with just your name on it right now, you have a car that has only your name on it, and your jewelry, your mink coats, etc. Those assets don't have a co-owner or a beneficiary. Those are considered your non-probate assets. Those are the assets that your loved ones, your survivors, will have to go through probate court in order to transfer those assets to the beneficiaries. And the beneficiaries are going to be can be your lineal heirs, or your descendants, or I should say heirs. That should be what I put in the list. So again, your non-probate assets versus your probate assets, you have to go through probate. It's a petition. And even if you have a will plan in place, I'm not going to discuss trust. Again, that can be a little bit complicated. I'll just hit on it a little bit in the end. But even if you have a will plan prepared and you disinherit your entire family and you name people who are not your blood descendants, your heirs, your lineal descendants, have a right to object, just by nature of the fact that they are your blood. It doesn't necessarily mean that they will win, but they can certainly tie the estate up for several months, if not years, because I have at least 2 cases now that we've been in court for a year and a half because the sole heir objected, even though the heir is not a beneficiary and there are 10 beneficiaries listed. We've been tied up in court for a year and a half. And I don't see any end in sight because the court actually surprised me about how they are handling this. So that being said, be very aware of your probate versus your non-probate assets, your beneficiaries versus your heirs, and of course your children. That's a given. So regarding your house, that can be a probate asset or non-probate asset. Again, that's going to be controlled by the deed. And keep in mind, if you're married and the property is in your husband's name and your husband has children, if he passes away and you don't have a plan, or he doesn't have a plan in place, you are now going to own that house that you lived in with your husband for 20 to 30 years. You're going to own that house with his children. So just keep that in mind with the blended families. Have that conversation. Don't wait until it's too late. They don't really like to talk about it, but for those of you who've been married more than 10 years, I know you know how to talk to your spouse, and so that he thinks it's his idea. But you need to have these conversations, because what I've seen on the back end, it's awful. I have seen third wives who received nothing. The third wife, 9 times out of 10, is the one who is helping him when he's in his last stages, right? She's the one helping him go to the bathroom and bathing him and dressing him. And then she learns that the first and second wife are the beneficiaries on all the assets that he had, his pensions, his military pensions, his 401k, and she's got nothing. And she was lucky to get the house because we found out before he passed away and he took care of it. But again, you must have these conversations. Please don't take anything for granted. I've had high profile people in certain areas. I won't say because I can't say but so much. I'm not their attorney, but they were married with, to their spouse for almost 20 years. They had very young children. Her name wasn't on anything. And what happens is the women, the moms, are setting themselves up to fully depend on their husband. And then when he's gone, they can't even access his bank account, because it doesn't matter that you are his wife. If his name is not on those assets, you have to go to probate court. And if you don't have your own funds, your financial plan through Sibyl, in order to be able to afford an attorney, you will really literally be up the creek. And this lady is very high profile, and she probably lost her home by now, because I guess she was so angry about the situation, she didn't even want to retain me. My office, of course, did not assist her, but she hired someone who was not a probate specialist, who didn't understand that when there are kids involved, there's another layer that you have to do. And a lot of attorneys do not know about that. So again, keep that in mind about having your plans in place. Let me move on to my next slide, just to make sure I hit all the points. So yes, I already discussed the myths. People assume that the spouse automatically inherits everything. They do not. That your name does not have to be on the house. Actually, it does if you don't want to share it with his children, and that the court looks out for you. No, they don't. There is a what's called the intestate law. So if you or anyone you know passes away without planning in place, if you are married, then your assets automatically go to your spouse. But again, titles control. Intestate means you still have to go to probate court no matter what. If there are titleable, such as the house, assets that you can't, a car is easy. The mink coat is easy, but something that holds a deed, such as your timeshares and the home, you must go to probate court in order to transfer it. However, without a plan in place, if you're married, the court is going to deem that those assets go to your spouse. If you are married with children, those assets go to your spouse and children. As Sibyl already mentioned, the spouse only receives 1/3, the children receive the 2/3. And if there is one child or 6 children, those children must split the 2/3, and the spouse receives 1/3. If you are single and you don't have a spouse or children, your parents are your automatic heirs. If your parents are deceased, both of them, then your siblings are next in line. So if you're single and you don't want your parents to inherit for whatever reason, I'm just going to be very transparent. Neither my parents or my siblings or any of my assets. I have one child and she will receive everything, and I have it set up so no one in my family will inherit anything, no matter what. It's set up for my daughter and her haircut, but I have that set up in place. So if you don't want your family members to inherit in that order, then you must put a plan in place. Otherwise, that's what's going to happen. And I have found that 9 times out of 10 single women, especially over 50 years old, who worked really hard for their assets, it's not their family members that they're giving their assets to. It is usually a niece or a nephew, which you can't benefit if you don't put it in writing, and it's charities. So they're pretty much splitting the money up with either a charity or their nieces and nephews. They're not giving it to their parents, because your parents are at least, 20 years older than you. It's highly unlikely. My family is like Sibyl's. My grandparents, they lived to be well over 90 years old, but that doesn't happen for everyone. So you want to have a plan in place so that you have control, because to sit down with someone like Sibyl and make these plans for 10, 20 years, and then not plan for your afterlife, you're pretty much wasting your time and your money, because by the time your loved ones have to fight, because they will fight, okay? Probate court is siblings, okay? It's your children. So for those of you who are in denial and, oh, my kids get along, even the women who call me because one of their 2 or 3 children said, Mom, could you please set up planning? They call me and say, oh, my kids get along fine. I was like, ma'am, your child told you this for a reason. They do not get along. They do not get along. So all of your kids don't get along. And especially when this happens, because the one who took care of you maybe and, put off going to college or just decided to stay home and took care of you, that child will assume that they are entitled to all of your assets. But the law says all of your children are equally entitled unless you prepared a will or a trust plan that says this particular child is the one who inherits everything. And if you make those decisions, please make sure you make those decisions carefully, because if you don't discuss those decisions with your kids, they will fight in court. And the worst part about it is the person that you want to inherit, that is the person who's going to end up in debt defending the estate, because the person who's fighting it, all they have to do, especially in Georgia, is pay $30 and fill out a little sheet of paper that has your case name, the estate of, John Doe. I will say Jane Doe, since we're talking about women, the estate of Jane Doe, case number, their name, Stephanie Graham, I object to Lisa Graham as the executor. That's all they have to do. And it costs them $30. Meanwhile, Lisa, the person who you left everything to, she's going to spend $20,000 on attorney's fees in order to ensure that your wishes are met. And she still may lose, such as the client that I'm helping now, who was named as executor, but the heir is fighting her. So just keep that in mind. If you set up a trust, they cannot have those fights. So let me go through my slides really quickly so I can talk about trust for a minute. So a will plan, most of you probably already know a will, and I shouldn't say will plan. A will is basically you making a written plan for your estate. You are naming an executor, and the executor does not have to inherit anything, but 90% of the time they are also a beneficiary. But it's a person, it should be the person that you trust the most to do right by everybody, not just by themselves. If you are questioning whether or not this person is the right person, don't name that person. If you would not give this person your PIN number to run and withdraw bail money for you, don't name that person as your executor, because that person has complete control of your affairs. Your beneficiaries have to rely on the executor to do the right thing, to gather your assets and tell them what assets belong to them. So that's what your will plan does. It names an executor and it names your beneficiaries. It'll also discuss who you might want to be the guardian, as well as the conservator for either your child or for yourself, should you become disabled and handicapped. But this is part of your plan. It starts with the will. But again, a will can be contested. They are very tricky. I am also a county administrator. And the last 6 months, I have suddenly been appointed to cases in which there are wills involved, and they're not fun. And I can see from reading the will how everything could have been avoided. Because if you come to me and ask me to prepare a will, I'm going to ask you a bunch of questions about your family to determine whether or not a will is going to be a good plan for you. And most of these challenges can be avoided. But if you are seeking estate planning from lawyers who dabble in it, like they do family law and they do criminal law and they do estate planning, you're probably going to have a problem with that will. I'm just going to be frank and honest. Go to somebody who specializes, because then they can anticipate the challenges that are going to come up. And so if you come to me and say, well, I'm not leaving my daughter anything, I'm going to ask you why. And we're going to find a way to deal with that so your daughter doesn't come back later and try to contest the estate. So we already talked about what the will is. We discussed how you want to handle children. If your spouse remarries when you're gone, just know if you didn't set up a trust in place with your first spouse to prevent your surviving spouse from inheriting everything and then giving it to the new spouse, that's pretty much what's going to happen. The new spouse will, if they survive your spouse who survives you, they're going to earn everything. They're going to inherit everything unless you put a plan in place to keep those assets separate for the children that you have with your spouse or the children that you had before your spouse. And that's a good reason to deal with the trust plan. I already talked about the modern family, patriarch, the blended families. You definitely want to pay attention to that. Again, I talked about single. You want to have a plan, because otherwise it's going to go to your parents. And if your parents are gone, it's going to go to your siblings. And if you don't want your siblings to inherit, you do want to have a plan in place. And again, if you don't have a will or estate plan, you're going to go through probate court, which is what I discussed. The petition has to be filed. Your heirs by law must be notified even if you disinherited them. Yes, that is the law. They must be notified, and the court.
I'm sorry, Stephanie. We have like 2 minutes, and that chat box is full of questions. I've been sitting here with my head.
Oh, okay.
Yeah.
Let's get started with the questions.
Yeah, I'm so sorry, but I didn't
Okay.
know if you could see them or not. So I figured we better try to, let me roll back.
Yes, thank you.
Yes,
Yeah.
yes.
Okay, so
It's full.
should our children start financial planning at 18? That's a really good question. Financial
Okay.
planning, that's a civil question. I imagine you could do it at any time, but estate planning you can do at 14. Because our 14-year-old kids have 100 times more stuff than we had. So your child can start estate planning at 14. Sybil, you want to answer the financial planning aspect?
Yeah, I did. I answered it in the chat. I'm sorry. I'm scrolling down to some of
Okay,
the others. So
that's okay.
yeah.
I'll
So
fly on
was
through.
asking about, can you speak about business assets, or how do you protect your personal assets from your business assets? That's one question.
Okay, yes. So, yes, absolutely. So we can, a trust is a great example. What the trust does is basically a contract between you as the settler slash grantor slash creator and your trustee. So you set up a trust. There are 20 different trusts that you can set up, but the most popular trust is the revocable trust. And it's popular because if you put an asset into your trust and you change your mind later, or you want to sell it, or you want to invest, you can always take it out and do what you need to do. You can always cancel the trust, revise the trust, modify the trust. Most of the other trusts, you can't ever modify them at all. But the reason they're beneficial is because if you, okay, that was only 23 minutes. So, so if you have an asset that generates enough money, enough income for you to continue to live off of every month, then you can put all of those assets into the irrevocable trust. But your business assets are protected best by trust planning in conjunction with LLCs. You put the LLC within the trust in order to protect those assets. And as long as all of your assets are properly titled into the trust, like remember when I mentioned co-owner versus beneficiaries, your trust technically is a co-owner with you while you are alive. Let's say you set up a trust today, then your bank account, which is Stephanie Graham, would become the Graham Revocable Trust. And then everything I'm writing from there is written from the Graham Revocable Trust. So when I'm gone, my daughter can approach my financial advisor, can go to my investments, can go to the bank and flash what I like to refer to the magic wands. It's a certificate of trust that tells the third party when this trust was created, what county it was created in, doesn't list the assets, but it's a notarized document that says who was the original grantor, the person who created the trust, and who I named as the successor trustee. That's all you need to show when you go into the bank. When you go to your financial advisor, a lot of them will demand to see the full body of the trust, but you don't have to present that. But the full body of the trust basically breaks down who your beneficiaries are. It breaks down your assets, whether in the body of the trust or as a Schedule A annex. And again, as long as everything is properly titled to the trust, your trustee, which is basically the person who steps into your shoes when you pass away, essentially can transfer your assets within 72 hours, including the properties that are held by deeds. So they will receive what's called, they have trustee powers. And as a trustee, they are able to create, well, they can't create the deed. They should retain an attorney to prepare the deed, but retaining an attorney to prepare a deed to transfer the asset is a few $100s versus having to go to probate court where you're going to spend a few thousand, even if it's uncontested. And if it's contested, you could spend well over $10,000 to $20,000. So your business assets, like I said, the LLC. Mm-hmm.
No, go ahead. No, I was saying I'll add to the back end.
I was just
sorry.
Okay. Yeah, so that was business assets, basically just titling them to the trust, specifically your LLC. So I know a lot of people have a habit of owning multiple rental properties in their own name. And they say they're protected by insurance because of a type of umbrella policy, but that wouldn't prevent someone from suing you personally because all of the assets are under your name instead of an LLC. So you really should put each of your buildings under a different LLC. My husband and I have Insurance and
Yeah,
repos-
and so I was also going to say with your business assets, you can also do a purchase agreement or a cross purchase agreement. And this is where maybe you have someone else who's identified who's going to be your business assessor. And because that is an insurance deal, insurance can bypass probate. So that's a contractual agreement, but you have to effect it perfectly. But this is where your family is made whole by the insurance policy, and then the other partner inherits the business. So there is a transfer of value, but that's also because it's done with the insurance contract, it's still done by contract. So having estate planning that also includes continuity and succession planning works in tandem. So there are a lot of ways to make sure that you are securing your business assets from your personal and leaving your family whole. And I think there was another question about, is it normal to have an attorney as your executor?
It's not unusual. I don't recommend it as long as it's not the person who prepared the documents, because they can't be. That's a conflict of interest. But if the attorney is, a relative, right? They are acting as your relative executor. They're not the attorney who prepared the will. So the person who prepared your estate documents should not also be the executor. I should say the attorney, because a lot of people are preparing their own wills, which is also a very bad idea. It's more than just paperwork, but yes.
And from the financial planner perspective, and which Stephanie has experienced that with me already, you can't put your financial advisor. If you do, you may want to question kind of who's the governing authority of your financial advisor, because basically FINRA and SEC will cast that down. We cannot be your executor on your estate planning documents. And people will just go and do it. So I advise that you ask the individual before you go paying these attorneys to put names in there that can't even go in there. And a person has a right to say that no, they don't want to be your executor. So just make sure that you ask before you start tagging people, because it is costly.
Absolutely. And you can name your financial advisor as like a what do you call it, Sibyl? As I guess an advisor with other members. I've had a couple of people do this, so it's not just relying on the advisor. So they have oh my gosh, I'm losing the words.
So
there's
what
some
we
families
do,
that create like.
Yeah, if you're asking me to do it, I have a company that can act as a trustee. It still distance me from that. But yes, if you're single, you really don't have family around, I am happy to get you connected to a trustee company that will handle this on your behalf. So that's what happens.
Yes, and you can name family members as trust advisors and ask that they consult with this particular person in their decision making for the family. So yes, but yeah, the attorney who's making the documents and acting as executor is probably going to lose his bar license. So I think that completes my time. I hope we addressed all of the questions, but I can be reached on all of the social media outlets. I'm Trust Attorney Atlanta. And yes, my office can assist with both trust planning and probate. We're one of the few that handles the planning as well as probate, and we actually litigate. So we actually will go to court and fight for you in probate litigation. And there's another question that popped up. Currently, well, it's I don't know if this is a question I can answer in 30 seconds.
Right.
So yeah, I'm happy to share our contact information. We do offer free discovery calls with our intake team. Or you can DM me because I don't want to take any more time, because it's a long question. Ariel,
And we
turn it back over to you.
Yeah, please understand that this is these presentations, we really tried to cliff note it for you. This is usually an hour discussion
Yes.
each. So that's why it feels like we
Yes.
kind of hit hit peaks of the mountains for you. But both of us
Yes.
actually offer a free consultation. So hopefully you have our contact information. If not, we can make sure that Ariel get it back out to you. And Ariel, thank you so much. We yield the floor back to you.
Absolutely. And just full disclosure for me, we don't do free consultations, but our intake team does free discovery call to answer basic non-legal questions for you. Thank you.